Welcome back to Law News, everybody. We were replaying some of the closing arguments in the Luis Toledo case out of Florida. That case is going to move on to the penalty phase tomorrow, as you all know. We are also covering a couple of other cases at Law News. We've got the Jeffrey Willis case out of Muskegon, Michigan. That's a case where a man is accused of murdering a young mother. Also, he faces separate charges unrelated to this instant case, related to the supposed murder of a gas station attendant and the abduction of a 16-year-old. And a lot of the evidence is mixed in together, making for an interesting case. The prosecution is getting evidence related to all three cases into the trial against the defendant, Jeffrey Willis, related to the death of the mother. We also are preparing to cover a new trial, which we believe will probably be starting tomorrow, so long as jury selection in Florida is wrapped up within the next hour or so. that case is the Matos case. It's the case where a defendant is facing 4 first-degree murder charges related to the deaths of his ex-girlfriend, his ex-girlfriend's new boyfriend, and his ex-girlfriend's mother and father. It's a really interesting case. It's got shades of domestic violence underneath, similar to the Toledo case in that respect. So that's what's coming up next here on the Law News Network. We also are going to switch gears a little bit and talk about another case from Cape Cod back in 2002 that's come back into the public consciousness because ABC News 2020 and an ABC News podcast series are really digging into it, and that's the case of the murder of Christa Worthington. Mari Henderson is an attorney who's going to join us now on Law News for about the next hour to talk about all of these cases. So, Mari, good to see you here on Law News.
Thank you for having me.
So let's jump into the Toledo case a little bit here, because we've been talking about that for some of the afternoon. You've got the death penalty phase picking up first thing in the morning, as we understand it. Just a horrible case. You've got the deaths of 2 kids, a wife. You've got a defendant who admits to killing the wife, points the finger at the neighbor, and it turns out the neighbor is the one that really went to police and led them to a lot of the really critical evidence. The bottom line is the jury just did not believe the defendant when it came to pointing the finger at the neighbor. The neighbor had no motive, and as the state said, motive is key. Now, it seems to me more likely than not, given the nature of the conviction, that this jury is probably not going to buy into very many mitigating factors in this case. You've got a heinous crime, the deaths of children here, and it seems that the jury bought into the state's case that the kids were probably killed after the mother to basically keep them quiet. I'm going to have a hard time seeing this case resulting in anything other than the death penalty, because it just seems that there's so much there. Do you agree or disagree?
I agree with you, because the fact that we've already gotten this far with the conviction for all of the murders, when keeping in mind this is a no body case, in fact no 3-body case, because the bodies were never found. So usually those are the most difficult kinds of cases to prosecute, and usually those are the ones that DAs tend to shy away from, because it is more difficult, because people want, the physical evidence, and there was physical evidence in this case. There was a boot, there was physical evidence along those lines at the crime scene, but when there's no body, it takes a certain kind of jury to convict a defendant in that case. So if they went there, I believe that they're willing to go all the way and give this defendant the death penalty.
Yeah, I mean, it seems that that's where it's heading, but I'm really quite interested to see what mitigating circumstances the defense is going to bring up. And I asked this the other day and sort of threw it on the table for discussion, and got a little bit of blowback from the guests that we had on yesterday. But do you think it's possible that the defense might take this thing, turn around and say, well, it's a mitigating factor that there was such bad blood back and forth between the defendant and the victim, and to sort of play up this angle, as he said to the neighbor, that I snapped, try to make it more into a crime of passion situation, and then say that the deaths of the children were related to this outrage burst? I mean, I'm just trying to figure out where else they're going to go. And I know it's a lame theory, but I just don't know where else they're going to go.
I mean, I think pointing the finger back at the victim is only going to backfire on the defense team. And, in the main trial, it makes sense to point the finger at her and say she was having this affair. It was a crime in the heat of passion, to get that second-degree murder as opposed to a first-degree premeditated murder. So it makes sense in the main trial to talk about the victim's own, cheating and affairs and things like that. But once you get to whether it's going to be a life sentence or death penalty, it really just comes down to the defendant himself and trying to prove that he's a good person. So, family members, friends can read letters, talk about ways he's helped them. People, who he's gone to church with, talk about how he's helped the community, talk about what he's done since he was arrested while he's been in prison, if he's, done anything good there. Those are more the kinds of things that the defense, I assume, will be looking to introduce.
I agree. Part of me wonders how this is going to roll once it picks up tomorrow morning, because at the tail end of the proceeding last week, after the verdict was read, the defendant told the judge he didn't want his attorneys anymore and that he was okay with just dying. The judge said, look, I know you're upset right now. Let's have this discussion at some other point. Presumably, that other point might be tomorrow morning. I mean, is this going to be a case where he demands to go forward himself? And the way I would see that playing out is the judge will probably keep his attorneys on the hook in the wings. But in theory, the defendant doesn't have to have counsel. It could set up for a very bizarre death penalty phase of this trial.
And it could also set up for an appellate issue, which is where I think this would be leading, is if he's saying, I don't want you to introduce any mitigating evidence, they have to, because that's going to be the biggest issue on appeal, is if there's no mitigating evidence introduced and he gets the death penalty when he didn't have a chance to defend himself. That's number one. And number two would be these issues with the counsel. So I think more than anything, this is the second the conviction came down, the defendant, I'd give him credit if he came up with this on his own or is just harping on the issues he's had all trial long with his defense counsel. But it sounds like the issues that have been going on are ripe for appeal.
I don't know if it's so much that he's having issues with his defense counsel as it is that he just doesn't want to live, is the way I took it. I mean, I know that sounds bizarre to us, because unless there's a breakdown in attorney-lawyer communication, then generally counsel remains on a case. But this is a defendant who tried to commit suicide when he was in the midst of an interrogation as well. So that he is still alive after at least one suicide attempt. His family's gone. He was horribly hurt by this affair. His reaction to it was completely inappropriate, but I do at least buy some of this the sense that he was incredibly hurt by what happened. I just think it sets up an issue on an appeal, but it doesn't sound like the run-of-the-mill client who doesn't like the attorney kind of issue. It sounds like there's something deeper going on there. Part of me wonders if there should be some kind of a mental evaluation. Maybe that's going on as we speak.
I mean, I'm sure will be on suicide watch while he's in prison. And then what's interesting is a lot of what we know is kept from jurors. So I'm sure the jurors were never told that he attempted suicide while he was in prison. The jurors were outside of the courtroom when he said he didn't want any mitigating evidence presented because he just wanted to die. And what's interesting is if any of that happens to come out through any of the mitigating testimony that he does just want to die and he doesn't want to live, that could play a role in their decision, because some jurors could say, oh, he wants to die, well then I'm going to make sure that he rots in prison for life and that he gets a life sentence instead of the death penalty, because that's exactly what he wants and that's what he's looking for. He's looking for an easy way out.
Well, I have to beg to argue with you about one of the facts here. The jury did indeed see the suicide attempt because the state was able to wiggle it in and say it was proof of consciousness of guilt, because he only did it when he was in the midst of the interrogation talking about, in at least his one version of events, what happened during the murder. He's sobbing, he's crying on the table, gets up, and yeah, the state was able to get that in under the Florida Rules of Evidence and say that it's evidence of consciousness of guilt. Interesting theory. I tended to agree with it if you watch the whole interrogation thing. So the jury did see that, but the jury didn't hear him say this to the judge. I believe the jury was already out of the room at that point when he said, after hearing the verdict, that he just wished to die.
And what's interesting now that I know that the jurors indeed heard that he attempted suicide already is jurors are told, one phase is done, move on to the next phase. And they, to keep everything separate. But come on, it's only natural to take everything you've learned, to take from your experience and take from the evidence you've already heard. So the fact that he attempted suicide already, like I said, may lead some jurors to swing the other way and say, this man wants to die because he killed his family and he wants his life to be over. That's the easy way out in his mind. And so instead, we're going to sentence him to life so that he lives out the rest of his days until he dies a natural death, thinking about what he did.
Well, perhaps that would be the worst possible punishment given the situation. We wondered that a little bit here yesterday. So Willis is going to start back up tomorrow at 10:30. I want to switch gears now and talk about this case that's sort of come back up in the public consciousness. This is the Christa Worthington case out of a town called Truro on Cape Cod. And this was the death of a 46-year-old fashion writer who was found dead in her home by a former boyfriend who came to visit. She had been raped. She had been stabbed to death. The stab wounds were very, very vicious. The knife wounds went all the way through her body. Okay, so certainly not just superficial. They were very, very violent from at least the appearance of things. She also had blunt force trauma to the head, which also impacted her death. Her 2-year-old daughter was found alive by her side. The daughter was completely unharmed. And this thing ultimately resulted in a lengthy investigation. The reason we're talking about it yet again is because ABC News, the show 2020, and also a special 6-episode podcast series have recently been produced to dig into some of the issues in this case. One of the big issues that came up years after the verdict was this. We had a verdict on November 16th, 2006. In January 2008, so a year and a bit later, 3 jurors independently came forward and said there was clear racial animosity on this jury. You had a white victim, an African-American defendant, and yet the appeals court said that just wasn't enough to overturn the convictions, in large part because there was DNA evidence here. There was DNA evidence collected from the body of the victim. It pointed to this defendant as a rapist and painted to this defendant as the killer. And the defendant had claimed he never knew the person whatsoever, multiple times in multiple interviews. And then yet his DNA shows up on her body in multiple locations. Interesting case. I'm just kind of wondering, what do you make of this accusation that these 3 jurors came forward and said some of the verdict was racially based? I mean, that would concern me, but it didn't concern the appeals court.
It wouldn't concern the appeals court if at the end of the day it was harmless error. Yes, there was juror misconduct, but would the jury have come to the same conclusion if it were not for that racial discrimination? And if the answer is yes, the overwhelming evidence in this case, including the DNA that you mentioned, is enough to convict that had there been no racial discrimination, it would have still led us to the same place, then it's harmless error. So I'm not that surprised with the appellate court's decision in this case. But again, in the court of public opinion and playing this out for podcast listeners and for 2020 viewers, they are going to have a different perspective on it. And I also think the timing of the case, we're talking about something, you're talking about back in 2006, we're in 2017 now, where racial discrimination, I think audiences are more adept at picking up on those issues and discussing, what underlies it and how it could have some disastrous concerns.
Yeah, I mean, ultimately, it was a 7-issue appeal. And look, at first blush, there's accusations before the appeals court that there were Miranda issues. One of the grand jurors who indicted the guy knew the victim. Okay, that's interesting. There's a conflict of interest there. The judge did not grant a change of venue. Now, keep in mind that the court that hears all of the cases on Cape Cod sits down in Barnstable, which is sort of on the lower tip, and then it has to deal with everything that happens all the way up and down the Cape. It's a narrow spit of land, but it takes some time to travel from one end to the other. You had no change of venue. You had evidence ruling issues. The discharge of a deliberating juror. Prosecutor, at least allegations, the prosecutor failed to disclose exculpatory evidence. Well, we hear that in a lot of cases. It's a big issue. The Supreme Court of the United States has already said, look, you can't do that. And then you have this issue about the racial animosity on the jury. 7 issues, but when you look at those issues on their own, they look really serious. And I want to say, hey, look, wait a minute, we need to look at this case up and down, left and right. But then when you look at the DNA evidence and you look at the defendant's own statements, it kind of seals the deal unless we find out there's something wrong with the DNA evidence. And I haven't dug into the case so far as to find that there was an issue with the DNA evidence.
DNA evidence is usually the #1 thing that jurors are looking for. You know, they want that CSI effect. And so usually in cases when there isn't DNA, that's when it's more difficult to prove. So the fact that there is DNA evidence, even with these 7 different appellate issues, if the jurors believe the DNA evidence, then the conviction, it was right for the appellate court to have upheld it. In fact, in my experience, there was only 1 case I've ever been involved in where there was DNA evidence and jurors came back with a not guilty verdict. And the reason I think why that happened was because one of the jurors on the panel was a writer for CSI and knew a lot about DNA and the ins and outs, and I think convinced the rest of the jurors. But other than that, every other case I've been involved in that has DNA evidence, they're usually those slam dunk cases that prosecutors want.
Yeah, agreed. And of course, we just covered the Toledo case. We just talked about it. I don't want to talk about it too much more, but in that case, there is no DNA because we don't even have bodies in that case. Yet that still resulted in a conviction. So it's interesting to look at the case from that perspective, that it doesn't require that, although agreed, prosecutors certainly like to have it. So we also have a couple of other cases we're following here at LawNewz. We've got this Willis case out of Muskegon, Michigan. Now this thing just has been discussed internally here at LawNewz as reading like a script from a bad or good, depending on perspective, horror movie. Good when it's fiction, bad when it's real life. You've got a guy, you've got a van, you've got this box of stuff. He's running around, according to the state, looking for women to attack, murder, syringes in this kit, guns in the kit, an orange cap on the gun so he can try to claim it's a fake gun when really it's a real gun, killing a gas station attendant who he had visited a number of times, killing this jogger by the side of the road, later abducting a teenager in the early morning hours who was trying to find her way home from a party, who was lost. It just sounds absolutely horrible. What's been interesting from my perspective is that the state has been able to get into evidence from all 3 of the alleged crimes in the murder trial that's going on right now related to the death of Rebekah BLETSCH. It's interesting because that doesn't always happen.
Well, the reason that doesn't always happen is because there has to be enough similarity between the different cases that it would help to prove some piece of evidence, like motive or character. If all of the victims were killed in the same way, some very unique way, or if it was the same type of person that he went after every time, then that goes to proving the identity of the defendant if the cases are connected. But there has to be enough of a nexus between all the cases or similarity to allow evidence about the other cases in, usually. And what's interesting to me is the other 2 cases of the gas station attendant and the one woman who actually survived and cracked this case open are going to be tried together. It's just the jogger's case that's being tried separately.
Yeah, the old 404B evidence, that's the rule we have to know as attorneys here. And what's interesting is a lot of states follow the federal rule, but my perspective sitting here at LawNewz covering trials in a couple of different states is that some of the different states interpret it a little bit differently. I was trained in New England, and I know that from my perspective, the judges are very cautious about bringing in too much of this evidence, fearing that it could be a death by 1,000 cuts for a defendant. You know, if there's a weak case over here, what better than to say that it's linked to this other case that he's charged with and try to throw it all in together, and then it results in demonizing the defendant rather than separating the individual crimes and making sure that the constitutional guarantee of proof beyond a reasonable doubt is upheld in each case separately. But what I'm discovering sitting here looking at trials from different states is that the different states interpret this rule a little bit differently, even though the language is the same. I'm curious from your perspective in California, 404B, how do the local judges tend to work with that rule in your jurisdiction?
So in California, it's an 1101B,
Okay.
and it's a high bar. It's a high bar here. There's one case that I worked on. It's a serial killer case. It's very similar to this. Unfortunately, more known victims, but where the last victim escaped and survived, which cracked open the case for everyone else, and finally led to the defendant going behind bars. But in that case, there were, I think, 15 different similarities for 1101B. We had a psychologist come in and really analyze all of the different cases and figure out the similarities and the way these victims were murdered, why these victims were murdered, the murder weapon, all of the similarities, enough to prove that we could get it in. And still, there's a question.
Yeah, so that when there is enough of a link, they can be tied together. Again, my perspective is usually that the judges are kind of afraid to go there, but I'm not licensed in California, I'm not licensed in Michigan, I'm not licensed in Florida, so we see these different approaches to it in different areas. It's interesting to me from an academic standpoint, but it certainly does make it easier for the state to get a conviction. In a case like this, where the evidence is very much the same across the line for each of the 3 cases that this defendant faces.
I mean, the killing of this jogger in and of itself is a brutal, terrible murder, but when you combine it with the fact that he also is alleged to have killed a gas station attendant and then attacked and kidnapped this 16-year-old victim, no juror in their right mind, with all of the evidence presented, would not find a conviction in that case. I mean, this is someone who, when you read it, you don't want this person on the streets ever again. The most chilling detail to me in this case is the fact that this defendant kept a folder called VIX with initials of his victims and files on each of these victims. I mean, that's kind of like Seven, the movie Seven. That's what it reminds me of. It's terrifying.
Yeah, and look, I mean, without the final accusation that he tried to abduct this 16-year-old, you wouldn't have an identification of the defendant at all. They were trying to figure out who had done these other things, and ultimately it was this 16-year-old able to get away, running to a house for help. Her testimony was believable. The testimony of the person who helped her, the person who just happened to live in the area where this abduction was said to have occurred, was believable. There was a lot of detail in it, talking about just how fearful this teenager was. Just this is horrible circumstance. Hiding in a bedroom because she was so fearful that more people might be out to get her. I mean, this was absolutely traumatic. But this teenager did have enough of a detailed description for the authorities to start looking at surveillance video from the area where this happened. And they finally got a piece of video that showed a van of this color going past at about the right time, okay? And they wound up giving that surveillance video to experts in the auto industry. And the auto industry experts were able to narrow down the type of van to the make, the model, the year, and they were able to figure it out based on the wheels and an antenna. Apparently these things are different in different models of this type of van, and they were able to narrow it down to about 30 people in that part of Michigan who had that vehicle in the motor vehicle registries, and that's ultimately what led them to this particular defendant. Now, I go through that whole track record because that's some phenomenal investigative work.
Yeah, I mean, when you have a serial killer, which is what this could be, on the streets, I'm glad that the detectives, left no stone unturned. And what's interesting to me is once you have all that overwhelming evidence, you have, okay, this is his vehicle, he's registered to this vehicle, he's driving around in this silver van. What's his defense? And here his defense is, let me blame it on my cousin who also drove around my car and took my car, and he's the one who actually killed these women. So it'll be interesting to see, now that the prosecution is rested and the defense is up, what's going to happen with their defense strategy and whether jurors will believe it.
Well, my take, and I hate to say this, but I'm going to say it anyway, my take is that the defense case has been pretty weak. I think the defense lawyering could be a little bit stronger, but then again, a lot of times the defense doesn't have many places to go. In this case, it's interesting that the cousin had some previous social interaction, contact with this particular victim, Rebekah BLETSCH, okay? And I came up with this list of things that sort of had come out in pretrial hearings that could tie the cousin to this particular one. Not only that, but you've got the cousin's statements with the other murder, the gas station attendant, of which this defendant is charged. And in that case, it's a question of, okay, well, how much do we believe this cousin? Because in one respect, the cousin is pointing to some of the critical evidence. The cousin's pointing the finger away from himself, but then the cousin says the gas station attendant is buried over here, and police have been up and down, left and right. They have not been able to find the body. So do we trust the cousin? Well, the cousin's tip as to where the body was is turned into a whole lot of nothing. So I'm wondering just how well the defense is going to try to stitch this all together and try to point the finger someplace else. But this cousin did result in a lot of evidence being recovered, but was wrong about some other big pieces of this investigation.
Well, this is a classic defense. It's called the Saudi defense. Some other dude did it. And usually, defendants or the defense team can't just point the finger without having credible evidence. So you can't say, oh, some other dude did it and this is his name, without any evidence that he actually is linked to it. You can't just bring in other evidence of someone else. But here, this cousin is charged as an accessory after the fact in some of these crimes. So he was involved. So they're basically just changing up the timeline. He's not an accessory after the fact. In fact, he's the person who did it all along, and that's why he knows about what happened later. And the fact that he's gotten details wrong and hurts his credibility can go either way. The prosecution can play it as, he's not someone to be trusted, ignore this, or the defense can say he's lying to cover it up for himself because he's the true killer. So usually, it all comes down to credibility for any witness, and this one will be especially important.
Well, I just went back and reviewed my notes here on exactly what the defense has argued at some point. So the defense has the case now. They want to play a lengthy interrogation of the cousin here. His name is Kevin Bloom. This is some of what we know. There's an accusation out there that the cousin, Kevin Bloom, had been Facebook stalking Rebekah BLETSCH. That's whose murder trial we're dealing with right now. Well, that's at least some evidence, okay? Bloom and BLETCH's kids played soccer together, so there's a chance they knew one another. Bloom knew BLETCH's husband through a social club, okay? So again, a little bit more of a tie here, back and forth between the cousin and the victim. The theory is, that there's just more entanglement between this cousin and the victim than just nothing. That there's something there. It's not just, oh, well, the cousin, basically told police a story about the gas station attendant's murder and therefore, led to information about the defendant. Here, it does kind of make one wonder, is the cousin more involved in some of this stuff?
Yeah, but the problem for the defense is they asked, will the cousin get on the stand and testify? And he pled the fifth. He pled, he doesn't want to incriminate himself in his accessory after the fact charge and in the other cases that he's involved in. So all the defense really has here is this 18-hour long,
interrogation,
interrogation that he gave to police. And it's interesting to me that the judge kind of put the brakes on the case, that they thought that they would just march in on here and play this 18-hour statement without giving the judge the transcript to read through. Because a lot of times you have to, when you want to play an interrogation or a police statement, you have to go through that with a fine-tooth comb because things may need to be redacted, especially in cases where there's dual defendants. So it's surprising to me. It seems like a last-ditch effort almost that they decided at the last minute to do this, because that transcript needs to be, they need to go through it very carefully because some stuff may need to be redacted.
Exactly. Well, it may be. Oftentimes strategies have to change in the midst of trial, and this may be one such case. But I can also understand the judge not being terribly happy with having to jump through all of the hoops at this stage in the case to try to figure out, okay, well, what can we show? How much can we show? Are we going to show it all? Are we going to show some of it? What are the relevant points? And from my perspective, if I were the defense attorney, I would anticipate that issue, and I probably would have been prepared for it. I don't think the defense had a really strong answer right out of the gate and say, well, Your Honor, we're asking first to play all of it, or if you deny that, in the alternative, we're asking to play these parts of it, and oh, by the way, here is everything we need in order to do that. You kind of have to go into a trial with plan A, plan B, plan C, and then be prepared for it, and they had to slam on the brakes, as you said, to try to figure out how to make this work at this point.
Yeah, I don't know if they thought that he actually would have taken the stand. Maybe he told them at an earlier point that he would take the stand and then decided upon his attorney's advice not to take the stand, and that's why it's his last ditch effort. That's the only thing I can think of as to why they wouldn't have introduced, at least for the judge, this transcript earlier.
Well, part of me wonders, and you tell me if you think I'm completely wrong, because I might be, maybe some of the concern out of this cousin is that he might say something in this case that could conflict with any testimony he would have to give in the case regarding the gas station attendant, because presumably he might have to testify against Willis in that case. So then you've got him, is he going to testify for the defense in one case and then the state in the other case? I mean, look at the conflict that creates.
Yeah, conflicting statements are ripe for impeaching him on the stand if he ever does take the stand in the later case. If he contradicted himself, and if there's contradicting statements between what he said to police, what he said in the first trial, what he's saying in the second trial. So, sometimes that just kind of moots the witness out overall when there's so many different conflicting testimony. You just don't even listen to anything they say. There's the jury instruction that you have to weigh the credibility of what this witness is testifying to, and it goes to the weight of the evidence. So if they don't believe the witness, then they can just basically ignore the testimony.
I want to switch gears yet again now, Mary, and talk about this next case that we've got covering up here on LawNewz. We are hoping it's going to start tomorrow, assuming jury selection is complete. And this is another capital murder case out of Florida. The defendant's name is Adam Matos. He's accused of 4 counts of first-degree murder related to the deaths of his ex-girlfriend, the ex-girlfriend's new boyfriend, and also the ex-girlfriend's mother and father. And one of the interesting pieces of this, from my perspective, is that there's a different cause of death for all of the different people who died here. So it's setting up a very, very, very violent crime scene. You've got blunt force trauma to the head. That's what killed the new boyfriend. His name was Nicholas Leonard. A gunshot right straight to the head. That's what killed the ex-girlfriend. Then you've got a gunshot to the torso. That's what killed her father. And then blunt force trauma and also asphyxiation on the mother. I mean, what's going on in this crime scene?
I mean, it could set up for the defense coming in and saying there was more than one person involved because there's so many different manners or modes of death here. I think that is weak. I think, maybe the mode of death lines up with the level of motive. I mean, he was very angry at the ex-girlfriend for moving on, so he shot her in the head. The parents were there. He decided to silence them and asphyxiate the mom. Obviously, there's a gun involved in at least 2, and there's a blunt force trauma involved in at least 2. The asphyxiation, that's a particularly brutal, lengthy way to die, and I don't know if it was, it'll be interesting to see the timeline of maybe he kept the girlfriend alive and killed the mother and father first and had her watch, and that he wanted a long, brutal death of the mother to make it an even more terrible, gruesome crime that this daughter watched. It'll be interesting to see the timeline and who died first, because I think that'll be important.
Yeah, I've got another question that I've asked a few other people here at LawNewz about, and this has been eating up at me since the Toledo case, because in that case, we had a domestic violence call. The next day is when we had a murder, okay? And it resulted in a conviction. This case is very, very similar. We had a domestic violence report on the 28th of August, 2014, and we had the bodies found on September 4th. Keep in mind that the bodies had been in some state of decomposition, so the murder did not happen on the 4th. You have to back up a couple of days. I'm not quite sure what the exact presumed time of death is, but the bottom line is some states have mandatory arrest laws when it comes to domestic violence calls. Some states don't. Florida does not. And now in a short time period, we've got one case, the Toledo case, where there's a domestic violence report, a victim saying to police, this guy threatened to kill me in the past. He showed up at my workplace, slapped me in the face, caused a ruckus. The relationship is deteriorating. I fear for my life. That's the Toledo case. Now in this new case, the Matos case, we have a police report here saying that the ex-girlfriend reported on the 28th of August, 2014, that the defendant showed up, demanded to know what she was up to the previous night and morning, ultimately pushes her up against the wall, holds a knife to her throat, and threatens to kill her. And her son woke up, and that's when the defendant fled from the residence. Now, that sounds violent enough from my perspective to trigger a mandatory arrest law in a domestic violence situation in the states that have that law or in police departments that follow that policy. But yet again in Florida, that sounds pretty serious, and yet we've got this defendant accused of murdering not only the person that he was alleged to have threatened, but that person's boyfriend and that person's parents. I'm connecting the dots here, wondering if Florida needs a new law. I'm kind of curious to know if your legislative hat is on and what you think of these mandatory arrest laws and whether or not they could have helped save more lives in this situation.
I think it depends on the situation with these mandatory arrest laws. So in the Toledo case, they had 2 children together. So I think that's a different scenario than in a case where it's just 2 people who are dating each other and they broke up. You know, when you are getting the court system involved in a marriage with children, I think that there has to be a higher bar involved and a higher standard involved than when it's just, a relationship. And there also has to be whether there was a pattern of abuse. If this was a first-time offense, then that would be different than if, a battered wife had called the police multiple times and it had gone ignored. So I think that these laws are important, but it always depends on the situation, and each situation needs to be judged on its own factors.
And some states have officer discretion written into these laws. Some states have what's called a pro-arrest policy, which highly recommends an arrest and a cooling off period in situations like this. I worked as a journalist in a state that has a pretty strong mandatory arrest law, and if there's a call of domestic violence, somebody is going to be arrested, period. Doesn't matter how big or small the issue is, but it injects the judicial system into the midst of what's going on. Now, some states might not have the judicial or the prison resources to deal with that. And part of me wonders if this is a policy call in Florida that just says we can't get in the middle of every single person's fight at home.
Yeah, that's why it has to be a judgment call on an individual basis, because a fight at home that involves children should be taken and viewed differently than a fight at home between 2 teenagers who are dating in high school. So it really does depend, but it is unfortunate that we've already seen 2 cases in Florida where there were domestic violence calls that then led to deaths, which may make for a stronger prosecution case in these cases. But the question is, should it have been prevented, and could we have stopped it from happening at all? So I wouldn't be surprised if these 2 cases, which are of a relatively high profile nature, someone who's running down in Florida makes this their cause as the next law that they want to get on the books.
Yeah, well, that's one of the next calls I have to make here at LawNewz, is to try to figure out what the legislature says about this, because I'm noticing case after case. Now, granted, 2 doesn't necessarily make a pattern, but from my perspective, it almost does. So the bottom line is we've got accusations of domestic violence in this case. You have what sounds like a very horrible crime scene. The defendant here used one of the victim's cards to buy pizza in the days after the crime. This is, I believe, the mother's card. So there's a lot of circumstantial evidence kind of tying this guy into what happened. You know, who else would have access to someone who presumably had been killed's card to use it to order pizza? And then the pizza delivery guy, I think, showed up and said something funny seemed like it was up. You know, one of the pizza delivery people reported a foul odor emitting from the residence. And then we have an accusation that the bodies were found presumably many days after they had been killed. Is this going to be testimony from pizza delivery people? It certainly sounds like it.
Not only pizza delivery people, but this defendant also allegedly sold off several different dogs that the family had bred on
that's
Craigslist,
right.
And someone who came to pick up one of the dogs also reported a foul odor. I mean, how dumb can this, you know, sometimes, you know, there's dumb criminals and then there are really dumb criminals. And I cannot believe that he would, you know, sell the family's dogs, order pizza to the home where he just killed these 4 people with one of the victim's credit cards. It's just like he's making it very easy for the prosecution to prove this. And it's almost like he had a complete disregard for them and their lives, obviously, in killing them. And then in the way he acted afterwards, he just didn't care.
Yeah, and then you've got this other neighbor saying that she saw a guy with this defendant's description spraying water in the garage and sweeping water outside of the garage door. That sounds like a partial cleanup attempt.
Cleanups are always an important part of trying to prove a defense. We saw that in the Scott Peterson case. We've seen it in other high-profile cases of, you know, if there's bleach in the home, if there's mops, if there's something that suggests there's been a lot of housekeeping going on lately, is that person trying to cover up the crime scene? And so I think that there's a lot of different witnesses here that are going to be very hard for the defense to overcome. The pizza delivery man, the woman who bought the dogs, the neighbor who saw the cleaning up, maybe the coworkers who saw, or the people who saw the violent fight in the 6 days before the murders. Any of these witnesses will be crucial to the prosecution, and it'll be interesting to see what the defense does with them on cross.
Yeah, exactly. I'm curious, but based on what I know of the case right now, I can't say that I have a lot of evidence that's going to bode very well for this defendant. It seems like a very, very strong prosecution case right now.
That's definitely the way it seems so far, so it'll be interesting to see how the defense tries to spin this. And I wonder if they will be bringing in any evidence of a second person involved, because there was so many different types of killings and, one person against 4. Are they going to try to argue that there was someone else involved here, or, someone else involved altogether?
Yeah, or possibly that the deaths happened at different times. They were somehow independent, and then yet the bodies were more or less stacked up. And the victims all lived together in the house where this all went down. So I'm really curious to see where the defense might go in this case, but it might be like the Toledo case. It might just be a very, very bad defense case.
Yeah, and in those types of cases, it just comes down to mitigating it. Can you try to at least prove that one was manslaughter or second-degree murder as opposed to first-degree, just trying to mitigate the circumstances?
Yeah, I'm curious. We're hearing that jury selection may actually have to continue tomorrow. Apparently, this is taking a little bit longer than we thought to get the jury seated. We certainly hope to begin carrying the case. Maybe we'll get lucky and it will start tomorrow, but apparently there's no chance that it would start first thing in the morning. At least that's what we're hearing right now. So, Mari Henderson out of Los Angeles, California, good to have you here on Law News. We appreciate your insight.
Thank you for having me.